Please. Thank you. Thank you. Distinguished guests and colleagues, on behalf of the Uzbek Arbitration Week Organizing Committee, led by TIAC Director Diana Bezakova, we warmly welcome you to the TIAC event entitled Technology Arbitration and the TIAC Rules for Technology Disputes. I'm Kirsten Tiro, and as chair of the TIAC 45 Young Practitioners Group, it is a great delight to introduce Claire Morel de Westgaver, who will be moderating this session. Claire is a partner in the International Arbitration Group of Bryan Cave, Leighton and Paisner, PCLP. She is qualified in England and Wales and New York with a mixed common civil law background, having completed her legal education in Belgium and the US. She practices international arbitration as counsel, advocate, and arbitrator, and conducts proceedings in English and French. She has experience in disputes related to technology, corporate transactions, licenses, cross-border sale or service agreements, as well as disputes involving secrecy, intellectual property, and cybersecurity issues. She's a co-founder of Mute Off Thursdays and co-chair of the Silicon Valley Arbitration and Mediation Center's Young Practitioners Group. She sits on the ICC Working Group on the use of information technology in international arbitration, the board of directors of SVAMC, and the advisory board of CyberArb. Most pertinent for this webinar, Claire is chair of the drafting committee of the TIAC rule amendments, which caters to technology disputes, in particular, Rules 20 to 22 and Schedule 2 on cybersecurity. Now, without further ado, I hand the time over to Claire. Thank you.
Thank you very much, Kristen, for this kind organization. And a huge thanks to all the organizers of the Uzbek Arbitration Week. It's a true honor to be a participant to the inaugural edition of the Uzbek Arbitration Week. So today we're going to speak about technology and arbitration, technology disputes, which we're going to define in a moment, and also the revised edition of the TIAC arbitration rules, which reflect the most advanced arbitration practices and are suitable for all kinds of commercial and cross-border disputes, as well as high-tech disputes. As we will hear today, some of the new provisions of the TIAC rules are particularly relevant to some common features of technology disputes and procedural issues that are common in technology disputes. To discuss this topic, we have a very impressive lineup of speakers who are all highly experienced in technology disputes and will bring their expertise and experiences from various jurisdictions, including the US, Belgium, Israel, Romania, France. Starting with Kathleen Paisley. Mrs. Paisley is a well-recognized international arbitrator. She's based in Belgium. She has significant experience under all major international arbitration rules and under common and civil law, as well as international and EU law. Kathleen is triple qualified, combining a degree from Yale Law School with an MBA in finance, and she's also a certified public accountant. She's co-chairs of the ICDR Global Working Group on Arbitration and Technology and Life Science Disputes. She's also a co-chair of the ICA-IBA Task Force for Data Protection in Arbitration. She's a member of the ICA-ASIL Damages Task Force and the Sedona Conference Drafting Committee on Arbitration. She was also a member of the ICA New York Bar CPR Working Group on Cybersecurity in Arbitration. Finally, she's also a co-chair of the in-house counsel forum of the ICC Task Force on ADR and Arbitration, and she's a member of the steering committee of the IMI CCA Strauss Mixed Mode International Task Force. Now moving on to the second speaker, Professor Kranguta Leawa. Professor Leawa is an experienced arbitrator and counsel listed by numerous arbitral institutions worldwide and named as thought leader in international arbitration by UzAW Legal. She's based in Bucharest, where she founded LDDP, a GAR 100 law firm. She's past vice president of the ICC International Court of Arbitration, and she currently serves as a member of the board of SVMC and a chair of this organization's working group on disputes relating to blockchain transactions. She's also a professor of law at the Bucharest University of Economics, where she teaches law for students of the Faculty of Cybernetics, Informatics, and Statistics for Economy. And also she teaches comparative international arbitration in the PhD program in law. We have also with us Alexander Blumrosen. Mr. Blumrosen is a founding partner of Polaris Law based in Paris. He's a member of the Paris and the New York Bar, and he serves as arbitrator and litigator in complex cross-border litigation. And also he appears as counsel in arbitral proceedings, and also as arbitrator, as I said, in a broad range of commercial of disputes involving commercial contracts, joint ventures, franchise and distribution, trademark and patent disputes, and e-commerce technology disputes. He appears on arbitrator's list of many arbitration institutions, including the Tech list, which is a list put together by the SVMC of neutrals, so mediators and arbitrators with experience in technology disputes. Mr. Blumrosen was appointed in 2018 as an arbitrator on the Privacy Shield arbitration panel by the EU Commission and the US Department of Commerce. And last but not least, we have also with us Shai Sharvit. Mr. Sharvit is a partner at Gornsky & Co. Based in Tel Aviv. His practice focuses on international arbitration and complex commercial disputes, either cross-border or often with a multi-jurisdiction involved. He has extensive experience in representing Israeli and foreign companies in arbitration, but also in litigation at all levels of the courts in Israel. And he's got experience in many types of disputes, including construction, insurance, shareholder disputes, technology and IP, class action, real estate disputes, and many other types of disputes. He's a member of the London Court of International Arbitration. He's a member of the INCITRAL Expert Group on High-Tech Disputes, and also a member of the ICC Commission on Arbitration and ADR and the ICC Task Force on Emergency Arbitrator. And finally, Mr. Sharvit serves as an ambassador of the ICC Commission on the Belt and Road Initiative. Now, welcome to all, my dear panelists. Before we dive into more detailed conversation on technology disputes and how the TIC rules can cater for these types of disputes, wanted to hear from each of you on what, in your view, is a technology disputes. Technology nowadays permeates all aspects of the global economy and all sectors. So what do we mean? What we have in mind when we talk about a technology disputes? I'm going to give you each of you 2 minutes to quickly tell our audience what a technology dispute is, starting with Mr. Sharvit. Shai.
Thank you, Claire, for the kind words and for the introduction. So as part of the work, both on the Silicon Valley Arbitration and Mediation Center and for UNCITRAL, the first stepping stone was to define what technology disputes are. It sounds relatively easy, but when you dig in deeper, it becomes more and more complex. And I think that the problem is that we cannot, or at least I was unable to define a technology dispute without using the term technology. Therefore, it's either you use the term technology as part of the definition or not, or find another definition, but I was not able to find another definition. So for me, in my eyes, the background of the parties is almost completely irrelevant. The sector of the dispute may be relevant, but at many times is not relevant. And therefore, the main definition would come out of the agreement between the parties, and whether the technology is the focus center, the focal center of the agreement or the dispute, because it might be an agreement on something else, but it's a technology dispute. And whether, it can relate to everything related to that technology. It can relate to sale, development, implementation, licensing, financing. It can relate to shareholders' disputes relating to technology companies and high-tech companies. And it can also address financing of technology companies. So it's really an open-ended definition that for us, the practitioners, either as counsel or as arbitrator, we need to understand whether this is just the core of the dispute, whether this is the focal point of the dispute, and stop there.
Okay, thank you. Kathleen, what is a technology dispute?
I'm not sure exactly what the Supreme Court said about pornography, but I think it has something to do with you know it when you see it. And I think that's a little bit like technology disputes. When, again, like Sherry was saying, when we were one of the first pieces of work that the AAA ICDR, but very inclusive organization for technology and life sciences disputes did was prepare a questionnaire, and which will be circulated very broadly. And we're trying to get as much feedback about technology disputes and life sciences disputes as we can. And although from the beginning, one of the things we talked about was the fact that kind of one of my pet peeves, there's think about the numbers, and then there's think about whether this really is a technology dispute is kind of my two pet peeves, is that, so we were very focused on the fact that, technology disputes were not just by traditional technology companies, it's also by other types of companies that in this case have a technology issue. So, we started thinking about that and talking with people about it. And in fact, if I talk to my colleagues, my arbitrator colleagues, and ask them, so when's the last time you had a case that did not raise a significant technology issue in the commercial sector? The answer is it's more often than not that there is a significant technology or IP issue, particularly if you include the sciences within technology. So we include scientific issues of life sciences, within that sort of broad definition of what constitutes a quote unquote technology dispute. So I think it's any dispute by any type of company that raises an issue. Again, it's very hard to do a technical issue, but where a technical issue is very important. But the question then is, and so, for example, if I ask you, construction companies consider themselves to be technology companies. Energy companies consider themselves to be technology companies. So when we were talking with arbitrators who are very involved in energy and construction disputes and push them a bit, they're like, oh, I'm a technology arbitrator. I hadn't thought about that. So, and that I think affects what kind of arbitrators you appoint, what institution you choose, how you structure the dispute. And often parties don't think about that because the counsel they appoint aren't necessarily that quick to pick up on the fact that it really is a technology issue. So I could go on, but nice to see everybody.
Thank you. Alexander, do you want to tell us in 1 minute, maybe, what is a technology dispute, or if you agree? You're still on mute, Alex. I'm sorry. Yeah.
Well, after our two comments already, there's very little left to say. I think we can categorize as a clear technology and hidden technology, and then technology is everywhere. So the clear disputes would be things like license agreement disputes, patent disputes, or construction disputes where, or aviation type disputes where a piece of technology is central to the dispute. But there are hidden IT disputes as well, where, and this is an important and maybe new point, which you may not know right away that the technology is the focus of the arbitration. You wouldn't know until the answer comes in or until the affirmative defenses by the other party are raised. And so it's important for the institution often to wait for the appointment and nomination of arbitrators to see what the answer is, to see if the hidden part of technology that is potentially in the dispute is actually a focal point of the dispute. But obviously, we're all going to find that technology disputes are everywhere. It's as if once you're a hammer, everything looks like a nail. So.
Great. And Professor Leo Kwangutsa, do you agree? Would you like to add anything before we actually continue the conversation from the perspective of the arbitrator appointment?
Thank you, Claire. I have a different perspective. And my perspective goes to what technology is. And basically the common definition of technology, it's application of scientific knowledge for practical purposes in an industry. So we have scientific knowledge applied in industries since, forever, different technologies for different moments in time. So what I believe is relevant is not whether it is related to technology or not, because somehow it will be related to some technology of some sort, because we are in this industrialized era. We do have application of science everywhere. What I believe is relevant is the common level of knowledge or advanced knowledge of a regular lawyer on that type of industry and knowledge, scientific knowledge. So whether we have common knowledge that everybody can acquire in a general school or in high school or by regular behavior in being immersed in a society, then it's not related to technology, even if it has a technological level. Like, for instance, the basics of using a pen. It is technology in that pen at some point. Not so advanced, but it is. So for that reason, I think that the distinction would be whether it is related to advanced technological knowledge or advanced level of science applied in that technology, which brings the novelty in. Rather than something that it is already in the common level of knowledge in the society. So that's the first point. And my second point is that I totally agree with Shai in terms of looking at the parties, looking at the sector or the industry, looking at the contract, or looking at the matter in dispute as possible angles from which the technology might be relevant to a specific dispute. But I would like to bring a new point, and that is, what is the matter in dispute? Because we have the core matter in dispute, and then we have issues that are not at the core matter, but are equally important. Like, for instance, interim measures that would be related to something related to technology. If you want to freeze assets that are like, for instance, cryptocurrency or all sorts of assets that cannot possibly be frozen in a typical way, but you need to think about it from a new technology perspective, then of course that you have something which is not at the core matter of the dispute, but it is still relevant, and you still need somebody that is aware of that area of the industry when looking at the matter. And then evidence, and that is the last subsidiary point. If evidence is heavily technologically related, like, for instance, data that it is stored in some sort of complicated advanced legal and technological area where we have the need for knowledge to get to that data, then even if the dispute is a shareholders agreement, if somebody paid or didn't pay the price according to the contract, then you still have a technology related dispute because of that element related to evidence. So it's not easy.
Very interesting. Thank you so much for all of your perspectives. So now that we understand a bit better what a technology dispute might be, how, and this is a question for Shai, how important is it to select the right arbitrator in a technology dispute, and how can the parties address the technical side of a dispute from the perspective of the arbitrator's background, knowledge, and if the arbitrators do not have the required background or expertise, is there any way that that this information can be provided to the arbitrators so they do have the required knowledge? Shai, can you talk us through this issue of selecting the right arbitrator?
So I think that generally speaking, for arbitration and specifically for technology disputes, arbitrator selection is key. Because although we are all competent, we are all good, and in Hebrew we say we all know the Bible, it's not straightforward to do a technology dispute before an arbitrator who knows nothing about technology and did only, maritime disputes for his entire career. I was asked that question many times before, and on occasions people ask if there are any formal requirements that parties should ask for, whether they have an additional scientific degree or whether they have an advanced degree in mathematics or similar requirements. But I think that generally speaking, it's more about how approachable is the arbitrator and how good he is in absorbing new information and new data. Because even as an arbitrator, even if I had a PhD in biology, that doesn't mean that I can do every life science disputes there is. So it's not just a matter of my formal education or my experience in work, because I argued before an arbitrator who was also, on top of being a lawyer, was an MD about a medical device dispute, and it was good to know that he had that background, that medical background, but he was not so receptive to other areas of medical. As Alex put it rightly, once you're a hammer, you see everything as a nail, and I think requiring formal education or formal background as a prerequisite is not the right way to go. Question is, what is then the right way to go? And I think it's a combination. And because technology disputes might have different requirements in different types of disputes. I handled IT disputes for hundreds of millions of dollars that had no urgency whatsoever in being resolved, fast. And I did shareholders dispute over high-tech companies that if the dispute would have gone over 6 months, there was no company left to run or own. So there are two, I think, I wouldn't say competing, but complementary requirements from an arbitrator. So he should command arbitration law. He should know how to run an arbitration efficiently. And I think that is the initial prerequisite. The additional prerequisite, again, is the fact that he will know how to approach technology. Not necessarily, again, that he will have the certain specific expertise. That would be a plus. But it's not always easy to know, formal education aside, who is good in life science disputes, who is good in source code disputes. I know from my experience, because I know, for example, Kranguta for quite a long time. So I know that if I will have a blockchain dispute, I will go to Kranguta because she will know how to handle it and she will know how to manage that arbitration. And she would be an amazing arbitrator in blockchain disputes. but I don't know if she's good on life science disputes. So again, and I think that relying on databases, on experience of arbitrators, on publications, on the variety of fields or topics or subject matters that they have dealt with throughout their career is a much more indicative way of finding the right arbitrator. And I think that, well, we are here under the TIAC logo and the TIAC rules. So I think that TIAC has done took a very good step towards that. And that is with Article 10.2 of the rules, of the new rules, that says that the TIAC court, in appointing an arbitrator, including the arbitrators nominated by the parties, shall consider such arbitrators' sufficient availability and the qualifications required for the fair and efficient conduct of the arbitration. And I think that that is a very important step in conducting technology dispute in a very efficient and just way. How it will be implemented, that's a different question, and how you should address those qualifications, again, whether it should be formal qualifications or experience, whether it should be, a general approach to technology, that's a different question. But I think that the mere fact that the court would have to consider those qualifications before appointing even the party nominated arbitrators is a very good step for addressing technology disputes.
There's another provision which I think we should mention. Thank you, Shai, which is new Article 22 of the rules, which concerns technical primers, reference materials, and tutorials. And so this is just for the audience. This is the possibility for parties to agree a set of technical information facts which should be provided to the arbitrators in a neutral fashion. So it's different from evidence, and it's there to brief the tribunal, to effectively give a course to the tribunal, whether on paper or as actually a tutorial, to make sure that the tribunal has the requisite information or background knowledge if they don't have it in the first place. But thanks again, Shai, for that insight on how to select the right arbitrator in a technology disputes. Now we're going to carry on the theme of expertise in technology, but more, not so much from the perspective of the arbitrator, but more from the perspective of the parties and the experts, either tribunal appointed experts or party appointed experts. And so, Kranguta, I was hoping that you could tell us how important evidence can be in technology disputes, and how that evidence can be different from the evidence that you might see in a standard commercial disputes.
Thank you, Claire. I think that the point that Shai made as to the, I would say, open-mindedness and mental availability of arbitrators to learn and to accept new information and to immerse into a new technical ecosystem, I would say, in which the dispute occurred, is to be matched with the help of experts, because those are basically the captains of the arbitrators' minds while navigating into this new sea of information. So experts must be for sure first to be able to educate the tribunal, and I welcome truly the 22 article on the point in which an expert is to give the tutorial on a particular scientific or technical information to the tribunal. Of course, that parties will do so, but usually parties are trying to focus on explaining the matter from legal perspective and to refrain from adding too much theoretical information to their pleadings, except if strictly needed. So possibly, indeed, the experts are in a better position to educate the tribunal, which is a different skill. It's almost like a pedagogical skill than that of being a well-known researcher in an area, for instance. You need to be able to explain something to a new mind that is now navigating into that sea of information, more like a guide. And for that reason, I think that first of all, we will see our experts not only being educated how to resist and be skilled in presenting their views in examination and cross-examination, but rather how to teach, which not always is the same skill. Not of them are coming from an educational background like academic or other. Usually they work in fields as experts with practical experience. So that is one point, selection of experts that would be able to do that as well. My second point that I would also like to highlight is that experts are also an interface for the tribunal understanding of other evidence. Because nowadays, many evidence, I would say more and more, and at some point in time will be the majority of the evidence, will not be written evidence in its strict sense. It will be data that it is stored in a way and then selected in a way and then presented in a way that requires technologically advanced knowledge. And I would give an example. It happened quite recently to have a case about a hydropower plant where the dispute was on the refurbishment of some equipment, but then a problem occurred, whether the problems in functioning of that hydropower plant were related to the way in which the refurbishment was made, or in the later operation of the power plant, and in the way in which the operating system was functioning. And for that reason, the experts need to access the data of the operation of that hydropower plant over almost 3 decades. And if that was the case, what it was possibly a matter of looking at the technical equipment only, in the end turned out to be looking at the data about the operation and make a selection of that huge data over almost 3 decades in order to be able to look at the patterns, at the anomalies in functionality and the source of the instructions that were given. So it was about collecting and assessing data. In that case, the experts needed to be able to do so, and also the tribunal was in the position of deciding blindly, because it was not able, neither the tribunal nor the parties, to directly access that data. It was not possible to look at the data by your own means as a member of the tribunal or as a counsel. You need to believe the experts. So in that case, if you only need to believe the experts, then it is an additional layer of responsibility as far as the experts are concerned. And finally, my last point goes to another article in the new rules, which I found quite useful. And that is about the experiments that may be conducted in order to demonstrate to the tribunal certain elements. And that experiment is a matter, experimental evidence, Article 21, also has the role of the expert involved, because it may be that the order of the tribunal goes to the party, that is 21.2, but it may be that the experiment will be presented to the tribunal by the expert, and that is the last part of Article 21.2. And those experiments usually require a certain capacity of being able to present to the tribunal the relevancy of the expert presentation on the experiment. Just to give you an example, it was a very important, let's take the hydropower plant as an example. This one, it's theoretical. If you look at some movies, if you look some recordings, if you look at even some sort of experimental in a way, like for instance, a mock case, an experiment that it is theoretical. It can be done by cartoons or by video animation. The tribunal understands something, but it will never understand the size of the matter. So the size of the matter cannot be possibly understood but by own senses of the arbitrator, unless the arbitrator has the educated imagination. And site visits in this area, I think, are crucial. And here is my point, my last point that I wanted to make, that the tribunal, even if the experts are the most important qualified experts of this world, even if they have the best skills ever, the tribunal should not forget that they have a role as arbitrator to do whatever it is needed to make sure that they fully understand themselves and they do not rely entirely on the experts. And I believe that this old-fashioned site visit feature should be reinstated, because it's the only one that may help the tribunal to keep their senses still there in assessing the factual issues and not completely interfaced by the experts. Thank you.
Thank you. And of course, Kranguta, the experimental evidence is actually exactly that. It's a site visit, but for something where there's no site. You are doing it before the tribunal, so they can see a reaction, they can see some data put in and some result, right? Very interesting comments about the need for arbitrators to actually comprehend themselves the technical aspect of the case. Actually, you know, in your case, you said that everybody had to trust the experts because nobody could really understand the data or the evidence by their own means. And I just wanted to actually make a link here with the experience of the arbitrators. It's possible that in an arbitration you have a three-member tribunal, with one of the arbitrators being able to understand some technical aspect of a case and the others don't. So something I think to keep in mind when you select an arbitrator in a technology disputes, you could have an impact on the deliberation of the tribunal if you choose an arbitrator who actually will understand the experts and will understand the technology, you know, him or herself. You may be in a situation where there's an imbalance in that way, which could be in your favor or against you. But I think something to keep in mind. We had a question from the audience, but I think it's great, but we don't have much time. So I wanted to just get a pool from you four. You all sit as an arbitrator. As an arbitrator, do you prefer in a technology or technical case, do you prefer to appoint your own experts or to see the parties appointing their own experts? You have only three choices, either one of those two or it depends. Kranguta.
I prefer the parties, but in the end, if there are matters of limited size, I would say I would also add a tribunal appointed expert only on those. It happened only once, so it's exceptional, but I would keep it as a safeguard.
Kathleen.
I'm with her.
Okay, Alex.
As always, I agree with Kranguta.
Okay, even in deliberations. And Shai?
Nothing to add.
Okay, right. So deliberations remain confidential, as they should be. Right, so we're gonna move on a little bit from the expertise now and discuss damages and quantum issues in technology, which can be very different from quantum issues that you typically see in the commercial disputes. So Kathleen, I was wondering if you could share your experience of what quantum issues in technology disputes as counsel and as arbitrator.
Thank you. If there's time at the end, I'd love to discuss with Shai and maybe with whoever drafted the rules, because I'm really surprised that the court would have a role in deciding whether an arbitrator appointed by a party has the requisite experience to hear a case. That is, I'm old, man, and that's troubling to me. To me, there's that really flies in the face of party autonomy. But that's if we have time at the end. So with respect to damages, I guess what I would say is, in a way, it's not so different, right? I mean, if you in a technology case, you have all the same kinds of damages issues that you have in any commercial case. You have a breach of contract, and you have to decide whether, but for the breach of contract, that you would have, had a different result with respect to whatever the issue is at dispute in the license or in whatever. And so what I find tends to happen is that because of all the cool technology issues that we've been talking about, the parties lose sight of the fact that they still have to prove their damages, and that their damages are, still have many of the same aspects that need to be proved in any commercial case. So that's the first thing I would say, that don't get so tied up in the cool technology issues that you're comfortable with, because that's the thing, right? If you're counsel in a case that is a technology case, you got to know the technology, and then you got to often have a very complex damages issue, not because it's a technology case, but just because the damages are complex for whatever reason. So that's the first thing. And that's where the expertise comes into play, right? Because it's also about your experts. And often what I see is that parties have decided to appoint a technology expert, so they may not appoint a damages expert where they should, maybe feeling like they don't want to overwhelm the arbitrators, yada, yada. But at the end of the day, that can be a major boo-boo. And then, so the other thing I would say is, there's many overlaps that people, I think, fail to recognize between the kinds of damages that arise, for example, in a big construction case, and the type of damages that arise in a big technology case. Because let's say, for example, you have a delay claim. What goes into the question of how you prove and quantify the delay claim may be different, but underneath it all, it's a delay claim. The same with respect, for example, to liquidated damages. Often big technology contracts are more likely to have a liquidated damages clause than other contracts, because parties realize that it's difficult to prove and time is of the essence. So often there will be an issue raised as to whether that liquidated damages clause should be enforced or not. Those issues are the same as in another commercial dispute. I do think when you're trying to value IP assets, valuing any asset, I spend a lot of my life talking about valuation of assets, and valuation of assets is always difficult, right? And actually, the valuation of an asset and doing a but-for damages calculation in a breach of contract claim is very similar. You have forward-looking events. You have to value those forward-looking events. You then have to decide what the risk factor is. You have to understand different aspects of risk. You have to understand the difference between the DCF elements, et cetera, et cetera. So I think they end up being rather similar, but because the nature of an IP asset is you can't touch it, you can't feel it, it can often be even more difficult to value any intangible, including an IP asset or a technology asset. So I think that the main thing what we see is that, there's a failure to recognize and often properly brief the damages issues in these cases, or that the way they're briefed is more simplistic than would otherwise be the case in a case where people were really focusing on the damages. With respect to how to do it right, I mean, it's all the things we know, right? It's doing the underlying analysis, making sure you've identified the risks, making sure you've identified the places of value. For example, I spend a lot of my time together with a life sciences company. The amount of value that goes into a program is huge. The benefit is huge, but the risk is equally huge. And to try and get an arbitrator to understand that, that balance between, yes, $10 billion for this drug is totally reasonable, but the likelihood of getting there is that big. So I think those are the kinds of things that come up in these cases. And again, I mean, it's why I think sometimes we do have to be careful being too prescriptive about what the skill set is of the arbitrator. And I would also say, just quickly, I mean, often people will come to me and say, so, who should I appoint? I've got this X case or this Y case. And as a chair, I think you often have to be careful about appointing someone who has too much knowledge in the area, because if it's a hammer, you're always looking for a nail problem, right? Because, I've done a lot of work in a lot of different areas, and I may have my own view, and that view may not match with one of the parties' views. And the parties may not know that because it's not clear from my CV. So I think where parties actually make a mistake is not spend enough time thinking really, really hard about the right party appointed arbitrator. Because you get the right party appointed arbitrator, they'll make sure you have the right chair, you get the right chair, so I think it's all part of the same environment that one has to look at. But you do have to be careful that with technology, expertise often comes bias, in my experience.
Interesting. There's an analogy between what you're saying, what Shai said about the selection of an arbitrator and the need to have, the ability for the arbitrator to have the ability to conduct the case, to procedural knowledge, as well as technical knowledge or technology knowledge. In your example, for example, of a delay claim, are you saying that, for example, that expert would have to have experience in both, quantum issues, delay issues, but also technology issues? Is that a fair, a fair analysis? And it seems to me that there are sometimes very small pool of people who can actually qualify for the job, and then there comes the problem of who gets first. If you are in a procedure where parties will appoint their own experts, if you have only one or two people in the field, who gets in first? Would you agree?
I think there's truth in that. I do think that most good quantum experts can, they're used to doing quantification issues in a wide variety of sectors. Like right now, I could name 5 who could do a great job on a technology case, and so it's unlikely those 5 are all going to have a conflict, but you're absolutely right that if they have experience in the area, it'll give them more credibility, of course, because they'll speak with more confidence, but also, they're more likely to get it quicker, the costs are going to be lower, all that kind of stuff. But I'm not sure the pool is that limited of people who, because I think the fundamentals of a quantification don't change. And the knowledge about the industry, they almost always have to learn. The first time you do a mining dispute as a quantum expert is the first time you do a mining dispute. I do think one thing I didn't mention is that I think quantification of infringement claims is particularly difficult. So you'll have what you may really want is an injunction, but there will often have been a period of infringement before you get the relief you seek, or maybe a long one, and that quantifying that piece, that value of the infringement claim is tricky. And the more compelling your expert can be on those issues, the more likely you are to have success. So I think there's I think some particular issues where, you know, the notion of intellectual property comes in, you know, overlaps with damages. But what I would say is it's almost always an error, you know, so you're going to have a technology issue and you're going to have a damages issue in an expert in a big case. And almost never can or should they be the same person. But each one of them should have some knowledge of the other's area of expertise, because we've all seen the case where the technology expert who's independent doesn't really know that they're killing your case on damages, but they do. And vice versa. So I think I do think it's there's a certain degree of knowledge between the two is really important in my experience. Shai wants to ask something. I'm sure it's going to be a hard question.
No, it's not a hard question, but no, you said that the damages evaluations or analysis is pretty much similar. When I look at high-tech disputes and high-tech companies in Israel, for example, especially now with the specs, every second company is merging into a spec in New York. Yep. And all of a sudden a company with no profit whatsoever over the past 4 years of its existence is, you know, being merged into a public company on the New York Stock Exchange for $2.5 billion. And it's very difficult for me, at least, because, you know, when I was younger, I took a course on how to evaluate companies and how to do a DCF calculation and a market value calculation. And nowhere there is there a way to understand and how you evaluate, you know, emerging technologies, how you evaluate high-tech companies that don't generate profit, but don't generate revenue, but generate tremendous value. And I think that some of the old valuation systems are not always valid to those types. And I had a case exactly like that when I represented a client who was one of the, well, he had a very, very, very interesting idea of turning international calls to voice over IP. And that was 2 years before the market caught up. And theoretically, he could have made billions, but for commercial reasons, the deal collapsed. And he had a claim. Now, do you claim under the commercial value of the agreement, the value you would have generated from that specific agreement, or can you now claim damages for what that high-tech company could have been 5 years down the road?
Great question, Shai, but it's too long. So, and also I think we really, I think it highlights perfectly the difficulty of quantum issues in a technology disputes. But I think we need an expert to answer that question. And by that I mean a quantum expert, of course, not an arbitration expert. All of us are on this call. But hopefully we get a flavor of the difficulties. So thanks for raising it. I wanted to make sure we had enough time to address another aspect of technology disputes, and actually it's quite a nice segue with the commercial issue that Shai raised. Because in technology disputes, it's not uncommon for both parties or all the parties involved in the arbitration to operate in the same industry, the same market sometimes, and sometimes they can be direct competitors. So what happens if some piece of information is needed for the resolution of the disputes, but it's also qualifies as trade secret. It's confidential information, sensitive information that one of the party is asked to disclose, but doesn't want to disclose it to the other side. Why? Because the other side is a competitor and might use it for other purposes. So, Alex, we wanted to ask you if there is any ways, any tools, procedural tools in arbitration and including in the TIAC rules which can help with that, with the preservation of sensitive information.
Sure. Thank you, Claire. I will keep this very short because we are running up against the end of our time. And I'd like to put this discussion in the broader perspective of why parties go to arbitration. Because just because you're a tribunal and you're before some parties, it doesn't mean that everyone is acting in good faith. Sometimes they are, often they are, and we like to think that often or most of the time they are, but it's not always the case. And as Claire intimated just now, there are examples, and maybe we've all seen them, where litigation or arbitration is a way to probe trade secrets or to get information. Around the world, there are blocking statutes where nations have said, we will not participate in US discovery, or we will not participate or let our country people, our residents, participate in foreign litigation for this very reason, because the litigation is often seen as a way to obtain information, trade secrets that for which there is no basis. There's no relevant relation to any underlying claim. Now, in certain national judicial systems, like in the United States, there are a series of obstacles and barriers that allow the court systems to protect some of this information. There are preliminary hearings, there are preliminary motions, there are motions to dismiss, there are motions for summary judgment. In arbitration, all of this is wrapped up in one proceeding before one arbitrator or one panel. And so it's up to the arbitrator and the panel to make, to protect that IP, to protect those trade secrets by these procedures that Claire was just referring to. And it is an essential part of an arbitral tribunal's role to make sure that the information that is disseminated in the arbitration is relevant to the arbitration, is needed for the arbitration, and is not being obtained for some frivolous or even malevolent purpose. And so how does the arbitrator do that? So in the arbitration proceeding, there are two protections. There's confidentiality of what happens in the proceeding vis-a-vis the entire world. And in the TAC rules, we see that in Article 32. So there is a confidentiality provision. And I'd like to mention that this is very useful and interesting and almost unusual because in many arbitration rules, institutional rules, there is no generalized confidentiality rule. And so when it comes to a venue for technology disputes and arbitration, the TAC has done a very good job in including a confidentiality provision in the rules. And it goes, it puts itself in the good company of WIPO, for example, which is another one of the few arbitration institutions that has a confidentiality provision for this very purpose, to protect IP, to protect trade secrets. So that's confidentiality vis-a-vis the entire world. Within the arbitration itself, as between the parties, Article 20 to 22, and I applaud the authors of those two articles. Article 20 provides for a mechanism, and this is a mechanism that can be available in any arbitration, but in the TAC rules, these articles specifically set out a roadmap for the arbitrators for how to deal with this kind of issue. So if a party raises a trade secret issue or a confidentiality issue or an issue of that kind, the arbitrators can appoint a magistrate or an expert who will have as a mission to determine the relevance, whether it's confidential, whether it's necessary for the proceedings. And this is a very useful function. Now, the arbitrators could also do that themselves. But this goes to Krenguta's very first response about what is a technology dispute, because this is one of those very narrow but important areas where it could be useful for an arbitrator, even if the arbitrator has technical expertise, to appoint an expert to look at that very narrow issue of whether a particular information or a particular data or a particular sequence of code that is at issue in the dispute really is at issue in the dispute, and whether it should be disclosed in the arbitration and under what circumstances. And having an expert opine on that very narrow issue could be very useful. And so I think the time requires me to stop, but there are tools, and very, I'd say, modern and up-to-date tools in this Article 20 to 22 of the TIAC rules that give a roadmap to the arbitrators to address this issue.
Thank you very much, Alexander, for that overview. And I think you actually set the scene quite well in terms of why this is important, why this is relevant. Another rationale for this, the appointment of an expert to look at evidence, is that of course you protect the arbitrators' minds, right? If there was a piece of evidence that was irrelevant but potentially harmful, or actually relevant but that should be protected because it's privileged or it's technically sensitive, only this expert will have seen it. The arbitrators will not have seen it. And I think it's important to recognize that there may be a need to keep the minds of the tribunal kind of clear of certain materials.
Yes, and I'd say that so trade secrets is one issue. Privilege can often be quite another issue, in part because the privilege issue could go to enforcement of the award. If I think we've all seen that there, as a defense to enforcement of an otherwise valid award, if you say that the very basis for the award is privileged information that the arbitration tribunal obtained or saw or was polluted with through this kind of process, then that in certain jurisdictions could put in danger the very enforcement of the award. And we're all here doing this in order to get enforceable awards. And so that's very important. The trade secret issue may not have that kind of consequence on enforceability, but it could certainly introduce irrelevant or misguided information to the tribunal, and having an expert would avoid that. Yes. So
Thank you. Yeah, I agree.
I also think we're going to see more of this with data protection experts. So I think there's going to be people. Yeah.
And Alex has been, as I said in the introduction, is a member of the Privacy Shield panel of arbitrators, and I think you mentioned before that you're seeing more and more appointments of that sort. So you effectively, the tribunal is not appointing a confidentiality expert, but actually an expert who's looking at all data protection issues.
yes.
Good point.
Absolutely. Kathleen's article on GDPR is absolutely brilliant and is the foundation for this whole area. But it is certainly an area of increasing delegation by tribunals and by courts, national courts, who simply either don't want to address the GDPR issues or want to have someone else address those issues in order to limit their own liability or responsibility for addressing them. And so that kind of delegation, I think, will be increasing as we go
Yeah.
forward.
We can have a little cottage industry.
With
Data
pleasure.
protection and you.
Thank you so much for those additional comments, and also Shai for your question, and all the panelists' contributions. It was super interesting and insightful for me, and I hope for the audience. Kristen, I'm going to let you close the event unless there's any question from the audience, which we would be happy to answer.
Well, thank you so much, Claire, and to all of the panelists. This has indeed been very insightful and thought-provoking. I also want to thank the attendees for joining us today, and please stay tuned for the other events tomorrow. Thank you all so much, and I hope we'll continue the conversation. As you can see clearly, this is a very insightful and I would say visionary development in technology, and there's so much more that we can discuss. Thank you all to all the panelists again. Have a wonderful day ahead. Thank you.
Thank
Bye.
you.